ஸ்டார்ட் பண்ணிட்டேன். இப்போ உங்களுக்கு வந்து கோஹோஸ்ட் கொடுத்துட்டா அன்சாத் என்டி தானே? அன்சாத் என்டி. நித்யா மேடம் உள்ள வந்துட்டாங்களா? நித்யா மேடம் கோஹோஸ்ட். இப்போ பாருங்க, நித்யா மேடம் பேச முடியுமான்னு கேளுங்க. நான் பேசுறது கேட்குதான்னு கேளுங்க நித்யா மேடம்கிட்ட. மேம், நித்யா மேம்.
ஹலோ சார், குட் மார்னிங் சார்.
நான் பேசுறது கேட்குதுங்களா?
கிளியரா இருக்கு சார்.
ஓகே மேம், தேங்க்யூ தேங்க்யூ.
ஓகே சார்.
மேம், உங்களை வந்து ஹோஸ்ட் பண்ணிட்டா?
எஸ் சார்.
நீங்க கெஸ்ட் யாராச்சும் இருந்தாங்கன்னா அவங்க கோ ஹோஸ்ட் பண்ணிருங்க.
ஓகே சார், ஹோஸ்ட் பண்ணி சார். சார் அப்ப ஸ்டூடண்ட்ஸ் ஒரு 3 பேர் ஹோஸ்ட் பண்ணுவாங்க சார். அவங்கள நான்
இல்ல, நீங்க என்ன பண்றீங்கன்னா ஸ்டூடண்ட் யாரு நீங்க ஹோஸ்ட் பண்ண முடியுமா? உங்களுக்கு பண்ண தெரியுமா?
அந்த சைடுல அவங்க செலக்ட் பண்ணி சைடுல போய்ட்டு அந்த இது பண்றது
அந்த டாட்டா இருக்கறத கிளிக் பண்ணீங்கனா
ஓகே சார்
பண்ணிடுங்க. இப்போ நான் உங்களை கோ-ஹோஸ்ட்ல இருக்கறீங்க, நீங்க உங்களை ஹோஸ்ட் பண்ணிறேன் நான்.
ஓகே சார், ஓகே சார்.
இப்போ ஹோஸ்ட் ஆயிட்டீங்க பாருங்க. ஹோஸ்ட்னு வரும் பாருங்க உங்களோட. உங்க பேருக்கு பக்கத்துல ஹோஸ்ட்னு வருதா?
சார் 1 செகண்ட் சார்.
ஹோஸ்ட் நித்யாக்கு பக்கத்துலயே ஹோஸ்ட் இருக்கும் பாருங்க. பார்ட்டிசிபேட்ல பாருங்க மேடம்.
இருக்கு சார்.
அப்ப நீங்க ஹோஸ்ட் ஆயிட்டீங்க. மத்தவங்கள அப்படியே அதே மாதிரி கோ-ஹோஸ்ட் பண்ணிக்கங்க.
ஓகே சார், நான் ஆட் பண்ணிக்கிறேன்.
थैंक यू மேடம்.
ஓகே சார், थैंक यू சார்.
இது ரெக்கார்ட் மட்டும் ஆகுதான், ரெக்கார்ட் ஆயிட்டு இருக்குது. அது பாஸ் பண்ணிட்டு அது ரெக்கார்ட் மேல ஆகுது பாருங்க.
ஆமா சார், இங்க இருக்கு சார். நமக்கு ஈவென்ட் ஸ்டார்ட் ஆனதுக்கு அப்புறம் நான் வந்துட்டு அந்த ரெக்கார்ட் ஸ்டார்ட் பண்ணிடணும் தானே சார்?
கரெக்ட். பாஸ் பண்ணிட்டு ஸ்டார்ட் பண்ணுங்க.
ஓகே ஓகே சார்.
थैंक यू.
சரி. சார் சார் அவருக்கு Sir?
Yes, madam.
Sir? Okay, sir. Sir, we will start our session with formal procedure, sir.
Fine. Okay.
Okay, sir. Okay, sir. Yashini?
Ma'am?
Can I carry on, ma'am?
Okay, ma'am. Mohana?
Start where you are, use what you have, do what you can. A very splendid morning and a hearty welcome to one and all gather here. Opportunities don't happen. You create this. With these words, on behalf of School of Commerce, Department of BCom CA, in association with Institutions Innovation Council, it's my immense pleasure to welcome you all for this one-day seminar on IPR and technology transfer. Now, I call upon A. Mohana from 2nd BCom CA to give welcome address.
Let us welcome your existence, which has been devoted to the clear ideals of goodness and happiness. With this quote, on this wonderful occasion, School of Commerce, Department of BCom CA, in association with Institutions Innovation Council, welcomes our most respected Dean Ma'am, School of Commerce, Dr.K. Devi Ma'am, and Dr. M. Segar sir, Head Department of BCom CA, for their constant support and motivation for organizing this seminar. On behalf of BCom CA, in association with Institutions Innovation Council, I cordially welcome you all for this seminar on IPR technology and transfer. Thank you.
Thank you, Mohana. Now I request S. Yashni from 2nd BCom CA to give brief introduction about the chief case.
I'm profusely overjoyed to take the opportunity to introduce our resource person of the day, Dr. K. Sankar Ganesh, Professor and Associate Dean, Faculty of Management, Sharda University, Uzbekistan. Sir has 22 years of experience in teaching and his areas of interest is research. Sir has published 8 books and published 50 international journals. Sir has organized and participated in more than 15 guest lecture programs and more than 25 training programs of students, teachers, and faculties. His aim is to identify and develop the new ideas for sustainable development and inculcating it to younger generation and preparing them to meet the challenges in the world and to contribute to corporate with the new academic advancement through best practices. I do not care so much what I am to others as I care what I am to myself. I welcome the resource person, Dr. K. Shankar Ganesh sir, to address the gathering on IPR and technology transfer.
Thank you. Thank you, Ashini. Thank you, Nitya madam and Dr. Sangeeta madam. Shall I start my session?
Okay, sir. Thank you, sir.
Okay. Okay, fine. So very good morning to the beloved students, those who are here online. It has become like every time when we speak on online, we say that this is a technological advancement and that is the before COVID, we have never thought about this. But before COVID, we have done some online meetings like this. I remember in the year 2018, before COVID, I have given 2 lectures to 2 different colleges in 2 different places. Of course, technology is keeping on changing, and when people start accepting and using the technology, it has become more useful. So that is how technology should be. And this particular topic, intellectual property rights, was given. And you see, why we need this IPR? What is the significance of IPR in commerce and business? Actually, it plays a vital role in business, especially every student from commerce and business should know about what is IPR and how it is done, how we are registering intellectual property rights and what all things can be protected, or something like that. May know, kindly please stop me when you have some doubts or something to discuss. You can just switch on your audio and stop me, ask me anything. Dear students, this is a wonderful opportunity you have to know about intellectual property rights. Okay, so let me just get into the session. Is my slide is visible?
Yes, sir.
Okay, thank you. So, I should say, like, why we need intellectual property rights. Can you recognize the symbols which you are able to see in this slide? How many of you may be able to recognize the symbols here? I think you can recognize Superman symbol, Spider-Man, the Flash, Hulk, Avengers, and Iron Man. These are the symbols which we have seen here. These all are the superheroes symbol, I mean logo, which is having a very good value of this logo. So each logo is having a very good value, which means that even a small kid registers the symbol in their mind and they recognize the character of superhero, which means like every brand is having its own value, and it has been you cannot copy it. You cannot copy it, or you cannot register it or somewhere else. Okay. So I would like to say the most valuable brand logo very recently, and for 2-3 years, which is standing in the #1 most valuable logos. Can anyone have a guess? You may be thinking about Apple. You may be thinking about Sony. And I do not know how many of you may be thinking about Google. Yes, Apple logo. Yeah, I got one answer. Apple. Google is in the most valued brand, and no one can copy that brand because it is protected. Okay, it is protected. And see, the company has taken much time, invested a huge amount for investing and creating some identity for their company, and taking the product or brand to the people. They are invested a huge amount, and after over a period of time, any symbol of that kind you will recognize, and you will understand, okay, this is the product, that company's creation, like that. So every company is doing work on it. Any creation which needs a protection. For example, if Hyundai or Honda's symbol can be easily copied, there is no protection. Then very recently there was a rival between Apple phones and Samsung. Samsung was claimed that they copy Apple phones model, and when Galaxy was introduced, they had the copy of Apple phones. But later Apple claimed that, and it was proved, and then Samsung stopped their model. They came out with the new models, which is not similar to Apple phone. See, one cannot easily copy others' creation. One cannot easily copy others' invention. That is what intellectual property rights are. It gives a person a right to use of his own. For example, you would have heard about Ilayaraja and SPB Balasubramanian's controversy. When they were doing, like Ilayaraja claimed, every time people are using Ilayaraja songs, hit songs on stages, and the advertisers, they are going to sing Ilayaraja's hit songs in the stages, and they want to pull the crowd. SBB was saying that the voice is mine, I have sung the song, and Ilayaraja has created the song, or written the song, composed the music, and Ilayaraja has done something like that as a director. But the singer is Balasubramanian, and the singer claims that I can sing because it's my own voice there. And when it went to court, the verdict was like, any product, any song or movie, it is for that the owner is the creator, not the singer. The creator means the music director, the composer, or even the production person of the music. Movie, or a director of the movie can claim as owner, but not the singer. And later they stopped announcing that. Whenever they had a program at Malaysia or Singapore, they stopped saying that it is not Ilayaraja song. It is like Tamil songs. And Ilayaraja claimed it for loyalty. If anybody is singing Ilayaraja songs in stage, he needs loyalty. See, if there is no protection, then obviously anybody can take anybody's creation, anybody can take anybody's invention, which is against human rights, which is against the rights of innovation. So when there should be an innovation, it should be protected properly. When there is a technology, it should be protected properly. And this is the purpose of having this session. I hope now you got some idea about what is IPR and why we need intellectual property rights. Okay. Let me define intellectual property rights. It's an invention or any creation of a person from industry or scientific or academic or literary or artistic, any field, if the person has produced his own content, his own invention, and if he wants protection for that, that comes under intellectual property rights. For example, the book written by the Philip Kotler, can you take photocopy of that book and sell? No, obviously, you cannot do that because it is protected. The book is copyrighted. The song, any copyright cannot be reproduced by another person. The poem, which is created by one person, cannot be reproduced by another person. It is illegal. So any trademark, any symbol which is created by one person or one company cannot be copied by another person for any commercial use or for any commercial purpose. Okay. So what all can be patented? Like patented comes under intellectual property rights, and copyrights comes under that, trademarks and trade secrets, even formula, trade secrets and formula. Okay, here you are seeing an example of copy, and which was stopped by the court. You can see here two types of shoes. One is Nike, which was launched in the year 1964 as Blue Ribbon Sports by company, and the person is Bill Bowerman. This was the company name, and Bill Bowerman, he launched this shoes for the first time. And later, Warren Lotas is another company in US. They came with a similar kind of shoe, which is also of good quality, And you can see the symbols, both are similar, which was used by Nike and which was used by Warren Lotas. But Warren Lotas was so popular because its quality of good product was also that much good. Later, Nike sued a case against Warren Lotas, and Warren Lotas was asked to stop the manufacturing. The court ordered them to stop their manufacturing of Warren Lotas of this brand, and they were supposed to pay some huge compensation because it cannot take the identity pride of Nike. It cannot enjoy the royalty. It cannot enjoy the prestige or quality aspects owned by the Nike. He cannot do that. And they stopped Warren Lotas later. And you can see Warren Lotas are having many more brands. It has bags, it has shoes, formal shoes, and many more brands. It's still a very big giant in this market, and they are US-based company. And this is another example of IPR. See, this company known as like National Biscuit Company, it was having shredded wheat. Shredded means fine quality of wheat. Okay, wheat bread. It has already having the brand shredded wheat, and the company name is National Biscuit Company. And you know, Kellogg's is also another cereal and food industry. It's also a very big giant in USA. They also launched shredded wheat bread, and later National Biscuit Company claimed it, saying that Kellogg is using their privilege of shredded wheat, and they cannot use the brand here like shredded wheat, and they cannot sell the product like that because already it is owned by National Biscuit Company and it is registered. And this came for discussion in the court. This issue came to the discussion in the court, and the court ordered that Kellogg was not done any damage to National Biscuit Company because shredded wheat is a generic name like pure oil, super fine quality. These all are generic word which anybody can use, and nobody can claim or stop others using the same word. It can be a brand, but not a generic words cannot be used. Okay. For example, you can see a generic word is like fine quality, best quality, super fine thickness, or some generic terms which will never stop a product's producer or a manufacturer saying that they have claimed this, they can claim this. Okay, so it is not an unfair trade practices or unfair competition strategy. So Kellogg's also can use this generic word shredded wheat, as well as National Biscuit Company also can use the generic term shredded wheat. So, because we should be clear what all covers under intellectual property rights and what all does not come under intellectual property rights. And this is another case, you may be knowing this. See, how many of you have seen Yahoo India, the symbol of Yahoo India? And everyone knows that Yahoo is a messenger company, it's an email company, it's an electronic software company. But Yahoo India is not the same company which is in USA. Many of the people, those who use internet, they confuse with both companies are same companies, but it is not so. Later, this Yahoo Incorporation, they filed a case against V. Akash Arora, and they argue to stop this using Yahoo India because it is confusing people that it is of their product. And if Yahoo India has been used, people will buy ignorantly as knowing that this is another product or brand of Yahoo. Then the court ordered to stop that Yahoo India, and now Yahoo India is not used in India, and Yahoo Incorporation is safe now. So see, they have created some value. Yahoo has created some value. Just like that, if you want to use others' value, which is not permitted, which is illegal. That is what intellectual property rights is. So any person's invention, any company's creation cannot be copied, or which is protected, which is registered. This is another case. Everybody knows this company, Parachute. Parachute is an oil company which advertises 100% pure. If you see in their advertisement, in their bottle, they would have mentioned that 100% pure. And you can also Google and see Abhijit Bansali. Bansali is a blogger, a YouTube blogger, and he used to review each and every product, and he used to publish the same video in his YouTube channel. He used to do that. So as he was doing many products, Parachute was also one among the product which he did. And he himself announced that the product is not worth of paying and he will prove it. This was the critic comment, which was given by Abhijit Bansali on this product, Parachute, and which was affecting the reputation of Marico Industries. Marico Industries is owning this brand Parachute, and Parachute is in the market for more than 40 years. And the person simply like coming and saying that the product is not just like that, worth of quality, and he says that he can prove it is affecting the brand image of the Marico Industries. And this company claimed to stop this video immediately, and they were asking for compensation for damaging their brand image. So since they are registered, they are supposed to be protected from any damages, any critics, or anybody's copying. The court verdicted that the YouTube vlogger should stop the video of saying negatively about any product without any evidence, and which was announced like no product can be or no creation can be hurted like this. So this is another issue where intellectual property rights is protecting your brand or your company's creation. And now we are seeing something about what is copyright. See, you may see some symbols of memorial, real life, caste, the origins, and the glass portal. These all are like top 5 books in the world. And if you want to take a copy, it may be some around 100 pages or 150 pages. If you are making copy and if you are using it for commercial purpose, it is illegal. Why it is illegal? Because it is protected through copyrights. The owner, the creator, I mean the writer of the book, he has registered that it is his own creation, which means that it's a copyright. He owns the right of that copy. Okay, what all can be copyrighted? What all can be protected like this? So computer softwares, any art or diagram, which is a creation of a person, a poetry work, a poem, graphic designs can also be copyrighted, and musical lyrics. As I told you, Ilayaraja's song was copyrighted, so you cannot reproduce it. So it's musical lyrics, any composition, novels, films, and original architecture of designs, website content. See, I would like to quote another one example in Tamil movies. I remember the movie Kathi. I mean the Vijay's movie Tupaki. Before it was released, it was facing a huge hurdle because of one single man. He filed a case saying that the story of the movie is his own script, which is not which is A.R. Murugadas has copied, and it was delaying this movie to be released, and later they proved that this is their own script, and later the film came to publish or theaters. See, any movie or any creation of a person cannot be copied. In those days, you may be seeing about audio cassettes. Audio cassettes can be copied, but original audio cassettes alone can be taken or bought. If you are pirating another audio cassette, called copying multiple audio cassettes, then it is a illegal activity. Okay. But after a release, after a release of a movie, after a certain period of time, they can copy, because any protection is for just their stipulated period. For example, patent is for 20 years of time. There are 10 years of protection also for copyright, 20 years protection for copyright. And it depends how they can use. That is why even in Germany, one of my friend was caught for downloading a new movie of Indian movie. So you know, everybody knows that there are a lot of websites called as Tamil Rockers or Tamil movies, where you can have pirated movies, and where you can have like new movies been released by somebody else. And Germany is having a very strong protection of intellectual property rights, and the person's website IP address was traced, and he has downloaded some movies, and he paid some huge money for that as fine penalty. So when a person's creation is done, he has put all his effort, he has put all his brain and thoughts for creating some innovation. It should not be just like that copied by another person. It cannot be just like that done by imitation by another person. So that is why even the website of any company is protected. It also cannot be copyrighted. It also cannot be copied. So a person's creation is that much protected. And I will tell you, like in our future slides, I can tell you how this concept of protection emerges and which country took initiation on this. You may be seeing this company's logo, and I think head and shoulders, everyone knows that Nike, McDonald's, Facebook, and Google. See, this is about trademarks. Trademarks can be anything, any word, any symbol, any slogan, any design, or combinations of all these three is all called as trademarks. And you can also have a lot of trademarks, like famous companies you can see here, Coca-Cola, Jaguar, Louis Philippe. These all are top world-class brands. And if you just see the symbol, and you will know about the company. Just that is called as trademarks. Something representing a company, something representing a person is trademark. Okay, so here the company can register their colors, their scent, their aroma, even they can register. For example, there are a lot of famous perfumes. They can even register the perfumes, and no company can create the same kind of smell having perfume. It also cannot be done. Okay, these all are protections. So when a company is doing something like this and registered, it is registered trademark, then no company can follow the same. No two companies can have same identity or same imagination or same image or anything of that kind. The reason is one person's creation should be protected, and one person's creation can be owned by himself or herself for a commercial activity. They can produce and they can sell. They can use their idea or invention and make money also for a certain period of time. Or a period of time they can use this. But after that, they have to renew it. If it is not able to renew, then any company can use it because it is not registered. It is not, the protection period is over. Patent tells about the utility. The utility means the person can use that. The patent gives ownership to the findings, to the design, to the process which has been invented. It gives exclusively to the person only who has registered, and that is the right of the person to claim, saying that others cannot use it according to the law. He can enter into any business activity, any commercial activity for that thing, and he will be the owner for the invention. So any design, any patents, any process, or any ideas can be patented, and we can use it for commercial purpose. So if you are starting any business in future, if you have some process in manufacturing, yeah, that process can be particularly patented, and no company can follow the same process and produce similar kind of product, which is illegal. Okay. So now I'm going to speak about the evolution of intellectual property rights, when it came into existence and who initiated. So France initiated intellectual property rights, and there were two constitutions on the basis of IPR system worldwide. That is Paris Convention for protection of industrial property, because Paris was developing in engineering and industries in 1800, and they were coming out with new ideas, innovations. They started giving more importance for inventions, creations, ideas, and they had an issue of other country people, other scientists copying it easily. So they created intellectual property rights, saying that if the invention is registered in the government, and the government will not permit anybody else to copy the same kind of thing. And in 1986, there is another Berne Convention for protection of literary and artistic work. This was raised by Germany, and Germany was again giving a lot of importance to quality works and inventions. So they also came out with intellectual property rights, and they made mandatory, if any product is registered under this IPR section, it cannot be copied. Then later in 19th century, many countries, majorly like Japan, USA, all the countries, they started doing this intellectual property rights as their legal requirement. As a government requirement, they started doing this, and it was followed by many other countries, and later it is popular. Now you can see India is ranking top 10 in patents. You can see 9th position in copyrights or something like that. Because you can see any country's growth is through industries, through science and technology. Any country's growth will be measured with their advancement in technology. And if they grow like that, and if somebody is just like that copying their invention, they have right to stop it. And that is how countries are now growing in this research, intellectual property rights and all. So it's an intangible property. It may be an intangible property also. You can even register your ideas, your concepts, that also can be registered. So intellectual property rights gives ownership, as I told you, and it gives a right of protection on the creation. This is one term if you want to patent something. For example, if you want to fix a name like if you want to start any beauty parlor, if you want to start any manufacturing sector, and you want to know that you want to keep a brand name, create a new brand name, and it should not be available, or if someone should not own the same brand name, because after fixing the brand, you will advertise and your investment, everything will be using that brand. And finally, you should not have a competitor saying that the brand is already owned by somebody else, which is going to affect your business terrifically, and which is not good. For that, before registering, there is a process called as patentability search. This patentability search gives or traces any previously registered brand of that kind is available. Any image of that kind is available in the registration. So it's a public government-owned search portal where you have to register and you have to pay some amount. You can search for whether that is already available or not. For example, if you want to see Bounce Beauty Parlor or Naturals Beauty Parlor, if you want to keep the same name, you just apply and search in the patentable search. You will immediately get that it has been already used by somebody else. Okay. And if you are using somebody else's brand name or any invention and any creation, the claim, whatever the person claims, the owner claims, will have to be given. It is like stealing others' ideas. It is stealing like others' property. So now intangible property also can be protected like stealing. Through this patentable search, you can avoid such things. And now I'm going to tell you about how or what is the process involved in registration in India. My dear friends, if you want to do a business, if you want to start your own business, please, surely you have to register. You have to register your company, you have to register your brand name, you have to register your logo, everything to be registered. And finally, because I have seen many of my friends changing their name after 10 years. I myself is a standing example. I will tell you my experience. We changed our brand name after 10 years of time, 10 years of getting popular and changing the brand name. Just like that we did it. Because of we didn't do that patentability search. We do not know about how far this business is going to grow, and in future somebody may claim that it is their own name, brand name or brand logo, something like that. So it is very much required for a business person to know about this, and it's very simple, very simple. See, there are many companies, agents for doing this. And no, not even agents are required. But if you pay 8,000 rupees, you can register a brand name. But you should do this patentability search and then go for it. For that, they will charge another 4,000. I have discussed with some agents, particularly they do this process. Okay. So first you have to write down the concept or the theory what you want to register. There is a non-disclosure agreement form. Non-disclosure agreement form means whatever you mention in that form, before it is registered, there are all possibilities to be theft, taken by somebody else. But if you are writing in this form, non-disclosure agreement form, that is an agreement saying that between you and a government employee or government department, saying that in between the time of public awarding or registering, it will never be disclosed to anybody else. It will be maintained as that much secret. So we have to include all the points which is related to your ideas or your generation or your creation. Okay. So if you want to create like a seawater and you want to convert it into a normal drinking water, I don't think it is patented by anybody else. They may have tried this. So if they go for some process, you may try for another process. For that, you have to give all the details. And you have to create that form. After creating that form, informing all the details and making that form, we have to check patentability check, and it is optional only, but to be on safer side, before registering, we have to do this patentability check. And patentability check is a website available so that anybody can register by making some registration payment and do that. If we are not doing that, there are some companies and agencies which are doing this process of work. Okay. After doing this patentability check, we will have a confidence. Okay, there is nobody is using this, or there is somebody using this. We have to change in the initial stage itself. So something like that. And then third is drafting, patent drafting. This part is very important because this is what the explanation completely we are going to give from our own ideas and our own words, our own thoughts. The idea should be drafted, and the draft should be conveying something which you have intention of conveying. That intent to do should be conveyed to others. And fourth step is filing the patent. After a draft, you cannot change. So once you make the draft, you have to check, edit, you can to review again and again, and then you have to file the application. So once the patent is applied or filed, then the government takes into consideration. They will search whether somebody else is having the same name or same process or same idea or the same book, something like that. Okay, then they start their process. At the fifth stage, they will publish the same in their journal. The government has their own journal, patent journal, and they will publish the same in the journal of the government, and they will wait for anybody is requesting for examination. For example, if the same product is registered by somebody else, and after publishing, anybody can claim that is their own idea, their own ideas, or their own creation, or their product, their process, anything they can claim, and they will wait for a while till somebody is opposing and to know about that. After that, if somebody is claiming that it is their idea or their process, then the applicant should respond to the objection. So somebody is claiming and somebody is objecting, and now the person has to respond. If the response is not justified, the patent will not be granted. It will be rejected. If it is properly responded properly, then the government will grant the patent. Many of us academicians and scientists, what they do is they publish. I mean, publish is not grant of patent. Publishing is the fifth stage. We say that we are published and we stop there. After publishing, we have to apply for the grant of patent. That is where the certificate comes. Publications does not mean that it is your own creation. So you have to apply for the grant also. Okay, so these are the stages of patent registration, patent, copyright, anything of that kind in India. And this self-disclosure, I was talking about the first stage, self-disclosure. This self-disclosure can be of any kind, any mode of doing presentation. A project report like kind of thing can be given as a self-disclosure. A presentation also can be done. A handwritten sketch or drawing can be done. You can talk to the video, I can make a video and you can send. That also will be accepted for your presentation as your ideas. You can also send any creation or scripts also. Scripts, written work can also be shared. That also will be accepted as creation. And we should choose what is required, and for that, which is the best mode of presentation is what we have to choose. For example, if you want to get a patent for a process of manufacturing oil refinement, you are doing it in a different way and you want to get the patent for it, better to make a video and submit a report. If you want to just like that register your logo, image is required. The image is enough, that's all. If you want to have a design, then photocopy is required, handwritten drawn sketches is required, and any flow chart if you want to register, that also can be done, but sketch of that is better. Here video is not applicable. So we have to choose which one is best, and based on that we have to go. So here I have a small video for 3 minutes, just 3 minutes, and just see the explanation of how to do patent.
I have an innovative idea in my mind. Can idea be patented in India? Well, the answer is yes and no. And let's find out in detail when it is yes and when it is no. The first question I would like to ask about your idea is how much details you know about that idea. Can we reduce it into practice? In technical terms, we have something called enabling. Your idea should be enabling. So when we say enabling, it's the ability of your idea to enable a person who is skilled in your art to reduce it to practice. So in simple terms, is your idea, is the level of information that you have about your idea is enough? Is it in detail and enough so that if the description about your idea that we are going to write patent, if it is given to a person who is skilled in your art, let's say you have mechanical idea and that person is mechanical engineer or knows about mechanical. If your idea is software, that person is so skilled in the art, somebody from the background from your field of invention. So if your idea disclosed enough and given to the skilled person, if he can reduce it to practice without any external help or additional research, can that skilled person in the art reduce the invention into practice? That is, reduce your idea into practice. Like, can he practice the invention? So what we can learn from this is, in simple terms, do your idea have enough details in your mind such that it can help somebody to practice it? If the answer is yes, then of course it could win patent. So how would you know if it is enabling or not? The ideal case would be you actually develop a prototype of it, but that is not always possible. And even the controller would not always ask for the prototype. In very rare case, the controller or examiner would like to view the prototype of your idea before granting a patent for it. But in most of the cases, even if you could prove on experimental basis or with calculations or on paper, like through algorithms and through the steps involved and by the diagrams and by the elements used in the diagrams, if you can prove that the invention or the idea has patentability or it has the inventive step, what we call in technical terms, then that is enough. So to summarize this information to simplest possible terms for the sake of this video, your idea could win patent if it is enabling, if you have enough details, steps, the diagrams, the illustrations of your device or your process of your execution of the software code, whatever it is, the flowchart and diagrams. So if you have enough of the information that could help a person to practice the invention, then it is enabling, and provided it is satisfying the patentability criteria that I already discussed in other videos, it could win patent. So I hope you receive some value out of this video, and you are in a better position to decide now whether your idea has potential to win patent in India and whether you should be proceeding for protecting your idea with subsequent steps. All right. Thank you for your time and take care. I have an
Thank you. Thank you for watching this. Yes. So I think now it may be very much clear about what all can be patented and how the ideas can be presentable and what are the ideas which all can be patented. So which has a provision to practice, which has a provision to follow, that can be patented. Okay, so any research can be patented, any findings of the research can be patented, any process can be patented, any business ideas can be patented. If you want to have, all of you might have experienced the same. If you want to register book a cab, what you will do, you will take your application, Rapido or Uber or any other application. Okay, any other Ola, or you just open the app and it identifies your location and you want to make your destination. You will tell that where you want to go. You will mention that. After that, what does the GPS does? It locates the people or the travel taxis which is around you. And once the person accepts, the nearest person accepts the your offer, and then you will see the person who is coming near to you, and the taxi comes near to you, and since it picks, you will be tracking the GPS through GPS. And who patented this technology? Uber has patented this technology. This technology was patented by Uber, and now the companies which is using like this, Ola or any other companies using like this kind of GPS tracking system for taxi or transportation, they have to pay loyalty to the company, this company. Okay, so if you see the international levels of top 3 patents, you can see China the number 1, US number 2, and Japan number 3. In 2007 and 18, China was ranking. See, that is why we see China growing like anything in industries, China growing like anything in research, because they come to know that research is the one advancement which is going to take the nation to the next level. So with that ideology, they started doing this, and they have crossed US. They are being the top positions in doing number of patents and number of copyrights of that time. And this is the world rank of IPR, which was published in 2018. And you can see China is number 1 in trademarks, designs, patents in all aspects. And you can see all the developed countries and fast developing country like India, and all the countries are there. It is really a very big surprise to see Korea there, because it is not a surprise. It is actually, they deserve that, because many years before, like China, they have started investing on research. All the countries which is having huge research potential, they come out with new findings, and obviously their new findings have been patented. And today you can see India is in 9th position of having highest patents and trademarks, in 6th position, and 12th position for a lot of designs registering. So after this progress happened very recently, over a period of 10 years of time, after our Narendra Modi ji came as Prime Minister, he promoted more for patent registration and copyright trademarks through India. So this all growth we have achieved in patent and research is between this more is of this 10 years of time. And you can see the growth overall on intellectual property rights protection. You can see, compare US and China, like the blue indication is US and Chinese indication is red. So you can see the steep growth, and it is also projected how it will be going after 2020-21. So both the countries are obviously going with the growth and stronger in registering patents. So this is the growth of patents all over the world, worldwide. In 2018, it was published, and it was about 3.3 million. Now it would have reached more than 4 million. They would have crossed 4 million. Steadily, and see the growth over a period of time, it is keeping on increasing. Exponentially, it's increasing. And what are the advantages? Why should we go for patents? See, the fees for registration is very less. I told, like, even if you go to the agency, you can register a patent with just 15,000 rupees maximum. And 8,000, I know many agencies in Chennai, Bangalore, and Mumbai, they are doing this. The fees associated with the government fees is very less. Government fees for registration is 800 something, and all over, more, with less than 4,000, you will get a patent from a government if you do not want assistance from anybody else. And we have a competitive edge. If we are having patent or IP protection, intellectual property rights protection, we have a very big competitive edge. I can tell you one thing, like after Uber doing this registration of GPS protection, no company can claim that that is their technology. So the company stands number one in the world with this technology because it is their own technology. Okay, if you see DTSI is one bike's technology, Bajaj Pulsar's technology. They have registered it, and that is being claimed by Bajaj only. Okay, so intercoolant technology is another company, Ford, I think, some company having the same technology. Okay, if you see Honda products, their technology will be written in their IV Tech or DI Tech something, and that is their technology. Twin spark plug is the technology of Bajaj Pulsar, and it was copied by TVS one product. I think I'm having the slide of that kind. So we have a competitive edge. No competitor can follow that. Okay, so the intellectual property enhances your value, the company's value. When the company is owning a technology, it should be registered, and after that, its value is increasing. The market value is increasing, and the financial business is also increasing, obviously. So it is always having its own value. When you go for international business, the people outside the world, they look for the patent rights, or the company's value is being judged by your research and your registration. So that is how it increases the value of the company also. Some disadvantages are there. So it's very few additional costs. Sometime every 10 years, if you want to register, if you want to renew, then it incurs additional cost, which is not a very big thing, but still it's a expense. And pirating is possible. Even if some products are patented, we can see a lot of pirated. If you go to some small shops near hotels, you can get small 5 rupee hammam soap. All the time, that is not manufactured by hammam company, HCL, which means to say that hammam soap products are pirated. You can see number of products like that. It will be typical looking like the same company brand, but there are a lot of pirating possibility. And 2-3 days before, I was searching for some movie songs, and recently taken movie is there in the YouTube. Somebody has published there. So all the time, the owner, all the time, the person who is protected, the person who is owner of the intellectual property rights cannot go behind people. It is also pirated. So these are the demerits. And intellectual property rights, major challenges also facing. It's facing challenges like evergreen prevention. Patent is not evergreen prevention. It is prevented for only 10 years or 20 years of period of time. After that, we have to renew it. Okay. Then subsidies and IPR issues. Many at the time, subsidies may not be reaching us. Some companies and some government is giving subsidy for special kind of invention, and it is not reaching. These are the challenges in intellectual property rights. And product patent process. We may tell that our product is going under this process and we are manufacturing such process, and we cannot change that process later. If you want to have an improvement, you cannot change. If you want to change, you have to change, and you have to again re-register your patent. That is also there. So traditional knowledges cannot be patented. So our tradition, our culture, that cannot be patented because it is very common. It is every individual citizen of India has the right to enjoy the tradition or enjoy the privilege. So such generic practices, such generic words cannot be practiced, or these are the challenges in intellectual property rights. I think you might have heard about this Kumaran silks and the Chennai silks. The Kumaran silks is very famous in Coimbatore. It was launched by a Tripur resident, and he launched a company in Coimbatore in the name of Sri Kumaran Silks. And it was becoming more popular. They were earning more profit later. They wanted to launch the same Sri Kumaran Silks in Chennai. They wanted to do that. At that time, when they went to Chennai, there was another company in the name of Sri Kumaran Silks, and that was a problem for them to keep their name, continue their name in Sri Kumaran Silks. By that time, they were very popular in Tamil Nadu, and they cannot keep this name in Chennai. That was a very big problem for them. What they did strategically, they changed their name, the Chennai Silks. Because earlier they were trying to change in Chennai, the Chennai Kumaran Silks, but it was not possible. Having two different names, the Sri Kumaran Silks in Coimbatore and the Chennai Sri Kumaran Silks in Chennai, which is not, people will not recognize the same company. They will see this as two different companies. So they have to change their common name, and they changed into the Chennai Silks. And now the Chennai Silks is so popular. Earlier it is called as Sri Kumaran Silks, and now they have changed as the Chennai Silks. And this peacock symbol is their logo, and they have registered the same. And they have spent more than 2 crores to establish this brand. In advertisements, in all the advertisement, they changed this name and logo. And this is the Coke bottle patent. And this was done in 1937. In 1937, Coke is enjoying this kind of modeling because Coke alone has a superb ergonomics design. If you hold the Coke bottle, the feeling which you get is different, totally different when you hold some other bottle. That is what the company is claiming. And the company has made a lot of investment in designing this Coke bottle. And now they have, since 1937, they have registered and they have patent. And no company can follow the same patent design or same model of bottling or no handling of this bottle. And that's their pride. So we are not much speaking about economy. So I'm just moving. And this is a famous icon. Even in Uzbekistan, people do not speak English here, but the most famous actor is Shah Rukh Khan. Everyone knows Shah Rukh Khan. Okay. And Shah Rukh Khan's name has been registered as SRK, and no one can use SRK in their branding. So wherever you can use SRK will be only Shah Rukh Khan. That's all. So it was registered in 2013, and he wanted to have his own name to be identified as SRK. And I think Simbu is also having the same kind of STR registration. Okay. Gillette company, I know it's a pioneer company in shaving instrument making. And this company has registered all its brands, all its model. They are the pioneer in making shaving instrument. And this company has registered their 2-blade, 3-blade strategy. And now any company is claiming or any company wants to manufacture, they have to pay 7 o'clock, or any company is going to do that. They have to pay loyalty for using the technology, using for the same model. That is the privilege they get. I was talking about this technology. A Flame, sorry, I remember now. The Flame is the one bike of TVS, and now it is stopped. It is no more in the market. And that bike claims that the the technology which they have is a twin spark plug, which was already a successful version in Bajaj, and Bajaj is saying DTSI, but Flame is saying that CCVTI, but same technology, name alone is different. And Bajaj started filing a case, 250 crores for defaming against Bajaj, saying that our business is completely affected because of copying of same technology. And they went for a compromise. And this just stopped, and it was settled out of court, I feel. And this one thing you should know. See, you know that in before 90s, turmeric was registered by America, and they told that turmeric is their product and their findings. And whoever wants to cultivate turmeric, they have to pay loyalty to America, which means that our ancestors have used this product, turmeric product, centuries before, and we have not registered. We are not registered, and we have not claimed for it. USA claimed it, and they started registering. They started announcing, saying that nobody can cultivate this turmeric. Now, Indian government took initiative. They raised this issue in the court, and they took all the evidences from libraries and from other published articles. Like we have used as a medical value and antibiotic for many aspects, and we told them that we are using for these many years before, and it is our own product. And later, court announced that the owner of the product is India. Turmeric is Indian one, and anybody else want to cultivate, because this is the one of the medicine for cancer. It's a very big antibiotic, and it's a medicine for cancer. So US want to claim that, and they took the initiative, but still out of Indian government action, it was stopped. And here it's a small 1-minute video about IBM leadership. Yeah, through this video, you can come to an understanding that which company is having more number of patents. IBM, no doubt in it. IBM is the company which is having more number of patents, and they still stand far ahead than any other company. This technology was introduced by Apple, and they have their patent also. It is face detection. Face detection was the technology which was found out by Apple phone, and all the companies like Oppo, Vivo, Samsung, whoever is following them, they pay a huge amount as loyalty to Apple company. After that, they are using the technology. During COVID time, people had a problem of wearing mask. Every time if they want to unlock their phone, they have to remove their mask, which was a health issue even, and which was a problem to many of others. So they came out with the technology which is helping without removing the mask, your phone will be able to understand you. So that technology was launched by Apple. And this is another technology, like there is a screen broken like kind of technology. It's an app, it's an application. It is available only in Apple. Self-destroying application. You can see you can break your screen by playing that game and app. That is also Apple's patent. And Ford has a non-driver without driver, the sensor and the robot kind of thing, which is installed, it drives the car, and they have tested this. Okay, so this is a patent done by Ford, and Walmart has introduced a lot of artificial intelligence robots, and these robots are used for cleaning where human cannot go. I mean, below the tank, water tank, if there is a small space where human cannot go, that can be Walmart introduces that kind of robot for clearing that kind of spaces, and they also use for agriculture. So sowing seeds or something like that. So robots were invented, and this kind of robo is being registered by Walmart. IBM has another cloth apparel division, and this apparel division says that we can use for both climates. So according to the weather, the dress changes and it adapts to the surrounding, so that if it is very hot, it will not sweat. If it is very cold, it will not make you feel the cold. So that kind of dress material they manufacture, and they came out, and it is most useful in many places like US also. So during winter they face -10, -15, -20, and during summer they even face 30, like in India. So which means that the variation is very high. So that kind of places, for such places, these products will be highly useful. And Disney came out with interactive ebook. So the content will be explained, and if you want to know the meaning for some word, it will be explained and the story will be also conveyed in a interactive mode. This is an invention of digital media's age, and this Disney has taken the patent for this. And as I told you, Uber has more than 160 patents, and among that, most important thing is the GPS system. And this is the patent published by me. I have published a patent in 2022 January, and this patent says about how to use QR code in organization, and we control employees. For extracting the employees detail, you can use QR code, and by this QR code you can fetch the employees complete details, the salary, the attendance, their employment history, and their statement of any grievances, anything about an employee can be retrieved through QR code. Okay, so nowadays, if any identity card is there, you can see QR code, and if for every employee the QR code is generated when they enter the office, no thumbing. It's another kind of barcodes, that's all. But still, it was published, and it is in the process of grant of patent. It's a description about this QR code, and this is a company-wise, worldwide, companies-wise patents. In 1999, Samsung was topping in having more number of patents than IBM, LG, Canon. So it's worldwide, and you can see the top ranking companies. All these companies are having their own value. See, just like that, they do not come. They have invested huge amount in research, and they have published this many patents. They have registered this many patents, and obviously they have become more strength technologically and in the process also. And IBM is the ranking first in USA, and this was published in 2016. And innovative machines or business machines, again ranking was compared, and in 2020 IBM was first, Samsung second, Canon. All these companies, they consistently stand, and they know the value of research and registration. So thank you all for your valuable time and spending huge time with me. This is the website where you can go and do your seeing, that is, what are the most important things about registration. Okay, thank you for listening to me. Let's have time to discussion. So we have 10 more minutes, 13 more minutes. You can ask any question. We can have discussion now. I can say one more thing. Virat Kohli has registered his face. His face has been registered, and because once in an advertisement, he was seeing his image where he was not at all concerned. I mean that his permission was not taken, and he was seeing his image. In that video, somebody was looking like him was used in advertisement. Because approaching Virat Kohli may ask, maybe demanding for crores, and somebody of his replica, somebody of looking like Virat Kohli can be used for lesser amount, and they found out somebody was looking like Virat Kohli, and they were having the mustache and the beard like how Virat Kohli was having at one point of time, and the same design and same cut it was given, and with the same personality. If somebody sees that, they will not understand that this is an imitation, this is another person. They will see that, they will understand that this is a Virat Kohli. And this was claimed by Virat Kohli in his court, and then he stopped that advertisement. Also, he patented his face so that he preserves that somebody cannot again use in anybody in any advertisement for his instead of his face, because it may cause damage to his image. So they do not know what they are making out of his face. So it may be used for good cause or some damaging cause. So he didn't permit that. So there are a lot of examples. Like if you want to have a number of examples, we can keep on telling examples like this. See, these all are lessons for us. As a business person, as a commerce person, we should know what is intellectual property and protecting that, how far it is important. It is not just like that. When you start doing business, if your father or your relatives are doing business, please ask them to register. I told you, I'm the standing example of a bad example of a person. So we started, I helped my wife to start a beauty parlor, and she was running two branches with a good fame, and she was having very good business also. After 10 years of time, and the brand name is Beyond Looks. Beyond Looks is the brand name. And after 10 years of time, I received a summon from Delhi court, Delhi lawyer, not court, Delhi lawyer, saying that there is a client already in the name of Beyond Looks, and they are doing a lot of business, and they claimed that I have used their brand and made business, so that I have to pay 17 lakhs compensation. There is a team which is working like this. They take any brand, any company which has not registered, and they will find out some companies that they're just like that send, and if you pay, you have to pay, that's all. Then what we did is, we had a lawyer, we had a thing, they were registered in 2007 or 6, and we had an evidence of running the same brand since 2003, but still we couldn't claim. And then we changed our name. Now, in all our advertisements, all our multimedia and social media's promotions, we are changed our name, and that is how we are doing. So all your effort will just like that go if you are not registering, if you are not protecting your intellectual property. Okay. So anything of your case, if you are a good singer, you can register your voice. If you are a sports person, you can register your in any part of your body also. That also can be patented, copyright. Okay, somebody cannot create the same kind of thing. Yes, now it's open for discussion. If anybody is interested, I will stop sharing the slide, and we can just discuss.
Thank you, sir.
Yes, ma'am.
So thank you for your valuable presentation, sir. You have given a lot of information about IPR from the beginning to till now, sir.
Thank you, madam.
So
Hope the students enjoyed. Dear students,
yes,
if you are really feeling good, please have your comments or have your ideas, questions, anything in the chat box, please.
Okay, sir. Surely they will ask, sir. So whatever the information conveyed by yourself, either video or presentation, all the information is very useful to our students, sir. Thank you for enlightening us. Thank you, sir. Thank you so much.
Thank you.
Sir.
Thank you. With pleasure, madam. With pleasure.
And also congratulations for your successful patent granted, sir.
Yes, madam. I have published 2 patents and I am working on one more thing. So very soon I will publish another one, I guess. So,
Okay, sir, wish you all
you know,
success,
we
sir.
have a lot of pressure also. Teaching is not that much easy nowadays. We cannot just
Yes,
take
sir,
class
yes.
and go. We have a lot of work, publications work, administrative works, all these things. In spite of that, we have to do this.
Okay, sir. Okay, so thank you, sir. So
Hmm.
today we had a good day with you, sir. Thank you, sir.
Most welcome, madam.
Students, if you are having any doubts, kindly unmute yourself and ask your queries, ma'am.
May I know anybody is having idea of starting at their business? If you want to become an entrepreneur, you should 100% follow this, because without intellectual property rights, your value will not improve over a period of time.
Yashni?
Ma'am.
Yashini?
Yes, ma'am.
Can you carry on, ma'am?
Okay, ma'am. Thank you, sir. It was really a great session. We got so many useful information from your words. Now I request V. Shanmati from Second Become CA to give vote of thanks.
Gratitude is the healthiest of all human emotions. The more you express gratitude for what you have, the more likely you will have even more to express gratitude for. On behalf of School of Commerce, Department of Become CA, we would like to record our sincere gratitude to our respectful management and Dr.K. Devi ma'am, Dean School of Commerce. We also extend our sincere gratitude to Dr. M. Shekhar Sir, Head Department of Become CA, in their absence. We place a heartful gratitude to the resource person of the event, Dr. K. Shankar Ganesh, for accepting our invitation in spite of his very busy schedule. His session on IPR and technology transfer was so contentful and useful to us. We thank every student participant of their enormous cooperation and involvement in the successful content of the event. Thank you all.
Thank you, Shanmati.
Thank you. Bye, students. Madam, shall I leave now? Can I?
Sir, thank you so much, sir. Thank you for
Thank you.
spending
Thank
your
you.
valuable time with us, sir.
Thank you, madam. Thank you.
Thank you, sir.
Yes, students,
Thank
lovable
you so much.
students. Thank you. Bye for your valuable time. And we'll meet in some other session in future. Thank you. Bye.
Thank you, sir.
Yeah, sir. Thank you, sir. Thank you.
Mhm.